Viasat is taking the Starlink issue to the next level, and with its filing in the DC Court of Appeals on Tuesday. More about that after this. Well, welcome back to Space Thoughts. Well, here we are, litigation, and what I think is really the first pertinent space law, space policy issue that has actually reached the federal courts. And we'll talk about that a little bit later, and my thoughts on that. Basically what happened was, for review from last week's video, Viasat basically asked for a motion to stay for the FCC to actually stop this license they granted SpaceX and perform an environmental assessment under the National Environmental Protection Act, or NEPA. Either the FCC refused or they didn't respond, and as promised, Viasat filed suit in the Court of Appeals for the District of Columbia on June 2nd. Now, understand, because this was we're talking about the motion to stay in particular and not really the substance of the matter. So fundamentally what happens is, under the federal rules, I believe it's the Federal Rules of Appellate Procedure, Rule 18, allows a direct appeal from a agency decision, in this case the FCC. So there were two things that were filed, and when you get to the appellate level, you're basically, first thing you got to do is file a notice of appeal, and that's what Viasat did. They basically said to the court, we have this issue on appeal. We want you to hear, and we want you to review this agency decision, and we're asking you to do this. And all that, and that appeal, that notice has to go out to all the parties involved, the FCC, and in this case also SpaceX. SpaceX being what we call an intervener, and interveners basically are parties that aren't directly involved in the decision by the agency, but they have a stake in it. In other words, they do have some standing in this. So they're also part of this in kind of a tertiary manner. The second thing that was filed was a motion to stay, and we're going to go over that in a few minutes. And this is basically a 35-page document. Now, motion to stay, they're kind of nuanced, and basically what they are is, in my opinion, preliminary injunctions. In fact, basically the motion to stay that Viasat filed, about all 35 pages of it, basically has the form of a preliminary injunction. So basically what Viasat is asking for, it says to the appeals court, look, we know you haven't decided yet on whether or not to take our appeal, but they'll probably take the appeal. But during the time of the appeal, we want you to basically enjoin the FCC from allowing SpaceX to launch further Starlink satellites. So, in other words, during this whole appeal process, Viasat wants to stop SpaceX from launching Starlink satellites, and do this by the means of the FCC basically putting a hold on the license and the authorization that it issued to SpaceX. So, what's a preliminary injunction? Now, well, and again, this is U.S. law. So, if you're in another country, your judicial system is probably going to be different and might function different. But fundamentally, there is a preliminary injunction is a very critical thing. It has to be really decided carefully, because you're basically enjoining a party from performing something, performing an activity, and potentially incurring damages, while at the same, while a decision is being rendered by the court. So here, I'm going to take this up, and right here on the screen, a plaintiff seeking a preliminary injunction must establish that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in his favor, and that an injunction is in the public interest. So, and again, this is a direct citation from a Supreme Court case. I'm not going to give you the citation just because the case in particular could have some bearings on this matter as it moves forward into the actual appeal stage, and I don't want to look like I'm taking sides, but I think this quotation of what a preliminary injunction entails is very important. So in other words, you got to establish, if I'm asking for a preliminary injunction in the case of what Viasat is doing, I basically got to tell the court, look, when this actually comes up to appeal, or when this gets adjudicated by the court, I'm pretty confident that this is going to succeed. So anything I do here, by staying any actions on the part of the appellants or the defendants, it isn't going to really damage them any more than it would if I actually got a positive judgment. So I'm really, really confident that I'm going to win. So if you issue this injunction and enjoin, say in this case, SpaceX from launching Starlink satellites, it's really not going to be bad because I know I'm going to win. That he is likely to suffer irreparable harm in the absence of preliminary relief. So in other words, as Viasat, I've got to come in and say, look, unless you enjoin SpaceX, unless you put a stay on this and enjoin SpaceX from launching any more satellites, this is going to cause me, Viasat, as a company harm, and I got to articulate that in my motion, and we'll hit some of the higher points of their motion in just a few moments. But the bottom line is, says, look, unless this action is enjoined, in this case, launching more Starlink satellites, I'm going to be hurt. So I need the court to stop this while we adjudicate it. Oh, by the way, I know I'm going to win, so it's not going to matter anyways. And that the balance of equities tips in his favor. In other words, any potential harm that that SpaceX will incur as a result of this, of granting this preliminary injunction and this stay, it all balances out in regards to the public interest. So there's always the public interest argument is a popular argument and very effective argument. It's nuanced, and you basically twist it to whatever you need. It's what said the word twist. A lot of what our job is to twist things into our favor. So idea of it's a balancing of the equities. In other words, yeah, SpaceX is going to probably suffer some harm by enjoining them, but it's in the public interest to enjoin them until the court adjudicates our case. And oh, by the way, we know we're going to win anyway, so really, it's a good thing to enjoin them right now. And that the injunction is in the public interest. And again, the public interest, in this case, it's in the public interest to do an environmental assessment. Therefore, it's important that Starlink does not grow any further than it is right now until we've had a chance to actually perform an EA, an environmental assessment. So understand, this is all about whether or not the FCC was wrong about doing an environmental assessment. But at this point, we're at the stage of saying to the court, we want to stop SpaceX from further building on its constellation, or launching any more, or launching any more Starlink satellites, for that matter, because it's because it's one of those things we don't want any. It will cause more damage until we've had a chance to really sit down and assess it. So this is a pretty bold. Preliminary injunctions are always bold. And you're asking the court a lot, and it really is tough for the court. The court really has to, is in the hot seat, for lack of a better term, because they've got to decide whether or not it's in the best interest to basically damage the opposing party while they adjudicate the claim. So that's what's at stake here with this preliminary injunction. We haven't even got to the briefing stage yet, or the actual appeal of whether or not there should be an EA, or whether an EA is required. But at this point, we're just saying we don't want SpaceX launching any more satellites. We've met all these prongs to this test for an preliminary injunction, and we're asking you to grant it and stop it from launching. So I went through the motion to stay, and I keep on calling it a preliminary injunction because that's basically what it is. I mean, they basically follow the format for a preliminary injunction. And I'm just gonna, I'm not gonna sit here and go through all the nuances of it, because we could be here forever. And I know people have other things to do, and I have other things to do. But I want to hit some of the high points. And usually, what I did is I went through the headers of each of the throughout their through a motion, and just to hit a high point, and I'll give you some running commentary. So one of the first headings is the order erroneously relied on uncertainty as a reason to refuse further assessment. So fundamentally, what Viasat is complaining about is the FCC basically said in its April 27th report that all the science, and I'll use the term loosely because I think, in my opinion, the science really isn't settled, or even there is even really a solid opinion about the science is on this. They really, they basically said that because the FCC said there was uncertainty about the science, that it was a reason to further assess an EA. And understand, the FCC, right? The FCC basically has what we call a categorical exclusion for satellites from environmental assessments. That is to say, they look at NEPA and they say that satellites are categorically excluded, and that's at their discretion, fundamentally. So that is basically the root of the FCC's position on this. But otherwise, they've addressed a lot of Viasat's complaints or assertions, but and basically kind of just shot them down, and that's why we're here right now. So basically, first one is the order erroneously relied on uncertainty as a reason to refuse further assessment. And basically, Viasat saying this is wrong. They should have looked, they should have looked under the hood a little bit more, and looked at our science and our exhibits. Viasat is likely to succeed in showing that potential environmental harms from deorbiting warrants NEPA review. So, fundamentally, this is one of those prongs. I think it's basically the first prong of a preliminary injunction. You got to show basically that when this actually gets up on appeal, when we brief, when we do our oral arguments, we're going to be able to convince the court that the FCC was wrong and that an environmental assessment should have been performed. So this is basically stating we're going to win, and that's an important part of a preliminary injunction like this. Viasat is likely to succeed in showing that potential harms from light pollution warrant NEPA review. So again, they're building on that. We're going to win, and the court, and under that heading, they give more discussion about why this would be relevant. And again, we're not talking about actually reviewing the merits of the April 27th report, but right now we're just setting the stage for the preliminary injunction. Another heading: Viasat is likely to succeed in showing that increasing space pollution warrants NEPA review. So again, when we show you our information, when we discuss this at appeal, when you look at the record and all the exhibits that we submitted, we know on this issue we're also going to win. So again, this is in favor of granting our injunction. Allowing SpaceX to launch more than 1,000 satellites during the appeal will result in irreparable injury to Viasat. Well, so basically they're saying, okay, unless you grant, and we're basically putting the scare factor in. We are saying that unless you grant this injunction and stop Starlink from actually launching these satellites while you review it, or before an EA is done, there's going to be irreparable harm. There's going to be 1,000 more satellites up there by the time you decide, and this is going to cause problems. So that's, well, okay. I'll comment on that a little bit later. Another aspect they brought into this was actually launches itself. They actually Viasat talked about, says, well, all these launches are going to cause climate change and stuff like that. And a lot of what they're basing their NEPA argument on is climate change. Basically the argument is there is science out there, and I put science in quotes because I don't think this has been debated enough or discussed enough or researched enough to really say that this is hard. This is hard science, and that's a lawyer's perspective, not a scientist's perspective. But fundamentally, they're saying these ideas of re-entering satellites is going to cause climate, is going to cause chemicals in the atmosphere that's going to contribute to climate change, what have you. Another argument is, well, all these launches to put the Starlink satellite system in orbit is going to contribute to climate change, and that's really the first thing. And so what I'm saying is, okay, so you want environmental assessments for launches to put out to see how that basically does it. Now understand, this is just for matters of the preliminary injunction, not for the actual review of the case. However, the way this is structured, in my impression as I went through it, says, what, Viasat's basically showing us what their brief's going to look like. These are some of the arguments they're going to make. So fundamentally, in a nutshell, these are kind of all these all the headings that they argue in favor of an injunction. And of course, they talk about harm. They basically say, well, SpaceX really won't be harmed if we stop it from launching for what they said is just a couple months. I thought that was kind of incongruent, given they basically said that what was it? They're allowing SpaceX to launch more than 1,000 satellites during the appeal will result in irreparable injury to Viasat. Well, launching thousands of satellites is probably going to take several months, 6, 7, 8, 9, maybe even 10 months to do. And Viasat's just, saying this appeal probably take a couple months and won't really cause SpaceX harm. So I thought that was a bit incongruent on the part of Viasat's motion. But again, like I said, a lot of these things sound like the wording of what they're going to have in their appeal. I think there's going to be a lot of cut and paste from this that goes into their appeal. So fundamentally, that's kind of the argument of what they're saying. This is why you need to enjoin SpaceX or stop SpaceX from launching Starlink satellites. Will it succeed? I don't know. Bottom line is, okay, I'm gonna approach this from two respects. From a lawyer's perspective, when I looked at the motion and read through it and weighed their arguments or their assertions, personally, I think it's a weak argument. I think it's a weak motion to begin with. I mean, it really has it drags in policy, which I think it's going to bite Viasat in the butt, down the road eventually, and it's going to, I think it just doesn't have a lot of legal bite. I think a lot of it really plays on emotion. Now, that said, I still think there's about a 50-50 chance of this getting granted. And again, because when you put this in front of a judge or judges, it depends on how this is presented or what what judges are available at the time and how expeditious they want to get this injunction ruled on. I mean, this could be an emotional decision. If the judge has is an environment has done a lot of environmental things, they might get scared and say, what, we're going to grant this. On the other hand, if you have a panel of judges, they might consider it and say, no, we're not going to do it. So my odds of this, even though I think it's a weak argument, it's a 50-50 chance of this injunction being granted and stopping SpaceX from launching further Starlink satellites. That said, I think if the injunction is granted, I think SpaceX and the FCC have a strong appeal before the Supreme Court, and that's what happened. If this injunction is granted, they can appeal directly to the Supreme Court, and it would likely be heard expeditiously because of the potential harm that it may be causing SpaceX. And I think based on case law that I've looked at, I've looked at a few cases, and I found one in particular that I found really interesting and really close to what's going on here. I think it was a really good shot that if it goes to the Supreme Court, an injunction would get overturned. That's just my guess based on what I've read here in the motion and what I've read for case law. But again, 50-50, even though it's a weak argument, 50-50 it gets granted. If it goes to appeal, probably going to likely be overturned. I just wanted to talk about a few things here. As a lawyer, I have a saying as a lawyer when I'm writing a motion or a brief. My question is, am I breathing fire or am I blowing smoke? And the idea is, am I breathing fire? Am I using good, solid legal arguments to get my point across? In other words, am I using the law, or am I using emotions and policy and politics to try and get my point across? And so the idea is, if I'm using the law, I'm breathing fire. If I'm using policy, if I'm relying on policy and motions, I'm blowing smoke. Unfortunately, I deal with a lot of attorneys that like to blow smoke. So I gotta breathe my motions. I try to breathe a lot of fire to clear the smoke. Honestly, my personal opinion, and this is my opinion, I think Viasat's motion is blowing a lot of smoke. I mean, I don't see a lot of fire there. I mean, they did a nice job structuring the injunction, but again, I think they leaked a lot of what they're going to put in their brief into their actual appellate brief when it presented to the court, and probably what you're going to hear in their arguments. And I think and I found a lot of holes. I found some weaknesses that could probably get overturned on appeal. But some things that really bothered me, and I go back to the screen again. Well, let's look at the third line here. Actually, the fourth line: space pollution. What is space pollution? I mean, I presume they mean orbital space debris. Well, why not just say orbital space debris? Well, space pollution sounds a lot nice, a lot more, how can you say, emotional, a lot more, in your face versus orbital space debris. And space pollution brings in and kind of attaches itself more to this idea of NEPA applies in outer space. Now, all this, all my discussion here and all my talk of this motion, I'm basically on my underlying opinion that NEPA doesn't apply to outer space. And again, I have my reasons for that, and I'm not going to discuss them here. Again, that's kind of proprietary to my subscribers for my briefing letter and otherwise, but I don't think NEPA applies to space, and I think this argument that Viasat is likely to see shown that increasing space pollution warrants NEPA review. Orbital space debris and stuff, NEPA doesn't apply to it, because NEPA doesn't apply to space, and I'm just going to say that, and we'll leave it there. We could go into a discussion, but I won't on this video. So I really didn't like the idea of space pollution, and this again was one of the things I looked at, saying, you know, is this motion breathing fire or blowing smoke? And when you conjure up words like this, though, which I know the media will latch on to, and you know could potentially be brought up in future litigations, you know, this is like, I don't know if this was a good idea, because this, this is how is this going to affect litigation down the road? Am I appealing to the emotions, or am I appealing to the law? Well, this is this is basically appealing to emotions versus the law. Another thing I really considered when I was looking at this was, and this is towards the end of the motion, and look at the highlighted section in particular. This is actually part of the motion that I extracted, and along with the footnote, and one of the arguments against the Starlight satellite system in their injunction, which will probably go into their brief as well, is pieces of falling satellites can survive re-entry and kill people. And they cite a media report based on regarding the Chinese Long March 5B rocket booster that was tumbling in orbit a few weeks ago. And I just looked at it and said, okay, that's pretty dramatic. And especially when you cite no studies or anything else, but you cite a media report. So, am I blowing, basically am I breathing fire or I'm blowing smoke? Well, this is appealing to emotions. This is appealing to shock. Oh my God, this, space, unless I stop this, space debris could kill people, which hasn't happened yet. And well, probably won't, probably unlikely to happen. But still, that's going to reach, if a judge is reading this, that's going to reach right out and grab them, especially, and this is the important part. Judges aren't trained in the nuances of space law or orbital dynamics or things related to space or the policy surrounding space. And this is why things like this have to be approached carefully from a legal context. And I think personally, as an attorney, I think as a responsibility as an attorney, when I'm right, even though I'm representing a client, I'm also representing the integrity of the law. So something like this, seeing pieces of falling satellites can survive re-entry and kill people, which I'm using which has nothing to do with the preliminary injunction, in my opinion, but will, probably be good something I could bring up in a brief. It's just really, is this something, I really want to put in there? Does the benefit outweigh the negatives? And is this something that could really hurt law in itself down the road? And again, I'm coming from the perspective of an attorney. I have a responsibility to my client, but I also have a responsibility to law. Again, all this is my opinion. So I'm going to wrap this up with just a few comments about some of my thoughts on this whole fiasco. Fundamentally, I think this, I've said I've been looking for years, watching for years for the first real litigation relevant to outer space, and this is it, in my opinion. I think it's a bellwether for how this case plays out and how the courts handle it. I think will be a bellwether for how future litigations are handled. I think this case is very dangerous in the sense that if the judges who don't maybe understand the nuances of space law, and in particular space policy, national space policy, this could go sideways really quick and cause a lot of problems. And again, that's another thing as a lawyer. We have an obligation to our client, but we have an obligation to the law and the integrity of the law. So I think again, I think this is in my opinion, it's a very soft injunction, and I think a lot of this is going to carry over into their brief. We'll see when their briefs are filed, and I can actually look at them. But overall, I'm concerned about this just because of the fact this may open up a big can of worms that could cause problems. And fundamentally, in my opinion, this is about whether or not NEPA applies to outer space, not whether the FCC should have should have performed an environmental assessment under NEPA, but I think this really kind of comes down to whether NEPA should be extended to outer space. And I think I've mentioned this before, I think in my last video last week about this. It shouldn't, it doesn't apply to outer space, and it shouldn't be applied to outer space, but rather we should be making new laws. Now, on the other hand, if we want to apply it to outer space, I think that's Congress's responsibility. They should look at NEPA again, and if they say they want it to apply to outer space, then they should amend it that way through legislation and not have it really materialize out of a judicial setting like this, especially in something as contentious as this right here. And again, this isn't about whether or not I'm against the environment or not. Of course, the environment is important, but we have to have the right tools for the job. And instead of taking a law that I firmly believe was not intended for outer space and trying to jam it into outer space or into an outer space litigation. I mean, it's the old suitcase idea. When you had the closed lid suitcase, you stuff it full. You're basically stuffing that suitcase full of things that don't belong there, and you're stepping on it, jumping up and down to try and get it closed. This is basically, in my opinion, the legal approach to that. And again, this is all my opinion, and I'm just commenting. It isn't necessarily legal advice, but overall, we're going to see how this plays out. This injunction in particular will probably move pretty quickly. So when an order comes out on it, I'll look it over, get back on here, and look through the order and probably go through it a little bit more substantially than I did just glossing through this motion. And again, if you want to look at the whole motion itself, if you follow me on LinkedIn, I posted this. I made this as a post yesterday. I downloaded the document or uploaded the document onto LinkedIn, so you can download it from there and look at it for yourself. So again, the starter gun is fired, and what I see is the first real federal court case dealing with outer space has started, and I really hope we get it right. So until next time, we'll talk to you then.